Thank you for joining me for this presentation, The Role of the Certified Legal Nurse Consultant in COVID-19 Lawsuits, Part 1. COVID-19, the coronavirus disease that originated in 2019, has created a global pandemic the size of which none of us has seen in our lifetime. As the COVID-19 pandemic continues, it's obvious that there will be myriad COVID-19 related lawsuits on the horizon. In fact, thousands of COVID-19 related lawsuits have already been filed. Now, as you know, being a registered nurse, this is not a simple virus. And this is why certified legal nurse consultants are going to be pivotal to attorneys understanding the complexities of COVID-19 and the myriad types of cases that they're going to be handling. As a CLNC consultant, you're going to want to position yourself for this new and emerging litigation, which conceivably could last a decade or more. Throughout this presentation, I'm going to use COVID and COVID-19 interchangeably. When I say COVID, I am talking about COVID-19, the coronavirus that originated in 2019, and any associated mutations as of the date of this presentation. In this presentation, we are going to be talking about the types of COVID-19 lawsuits. In Part 2, that presentation, I will be addressing the specific services that you provide as a CLNC consultant and also factors that will be impacting COVID litigation. So again, in this session, I'll be talking about the types of COVID-19 lawsuits. And we're going to touch on a variety of types of cases, everything from medical malpractice, general negligence, products liability, workers' compensation, workplace safety, wrongful termination, intentional torts, criminal cases, and even some miscellaneous types of lawsuits. What makes COVID so interesting for you is that it touches almost every type of lawsuit. It's pretty amazing how vast this is going to be. Tom, my husband, he jokes that I wake up like the Queen in Alice in Wonderland, believing 6 impossible things before breakfast, and I admit I often do. But writing this speech, I really felt more like Alice falling down the rabbit hole, entering a strange and alternate universe of that far-reaching impact of COVID-19 litigation in the already strange and alternate universe of the pandemic we're in the midst of. So today, my goal is to give you an overview of what's already happening and what is potentially going to be happening. Everything that I discuss here today can be a session in and of itself. For example, if we were just to talk about long-term care facility lawsuits, that alone we could spend 2 days on. So I'm trying today just to give you an overview. So unfortunately, I'm not going to be able to give you every little thing about every type of lawsuit, but I'm going to try and give you quite a bit here today. So let's start with that first category, the medical malpractice cases. Now, as you know, medical malpractice, those are professional negligence cases. So a medical malpractice case, this is going to involve the professional negligence of a healthcare provider or the negligence of a healthcare facility. Hospitals, long-term care facilities such as a nursing home, home health care agencies, emergency medical services, urgent care centers, and then individual providers such as RNs, respiratory therapists, MDs. These are the players and the facilities that are going to be most vulnerable to allegations of negligent management and treatment of COVID patients. Now, when we talk about nursing homes, I also want to emphasize that you can see nursing home litigation under general negligence, which we will talk about here today. You can see criminal actions against nursing homes. You can see regulatory actions against nursing homes. It's going to be the attorney's job to decide how they are going to pursue that case. Are they going to sue under a general negligence claim, under a professional negligence, which is malpractice type of claim? And then even how they might handle these cases could vary from state to state. So we're talking about malpractice, medical malpractice cases. And to kind of give you some background, in a medical malpractice case, the plaintiff has the burden, the legal burden of proving 4 legal elements: duty, breach of duty, damages, and causation. Now, it's the plaintiff's burden to prove all 4 of these legal elements. If they miss any one element, the defense will actually win their case. So today, when I talk about allegations and defenses, you'll see that some of the allegations or some of the defenses rather, relate to breach of duty, but they can also have defenses related to damages and causation, because if the defense can basically disprove any one of these 4 legal elements, they will win that case. Now, with the duty element, basically you're helping the attorney identify who's got the duty here, which RN, which MD, or which group of RNs, which facility had a duty, and then did they breach their duty? And so the breach of duty is that failure to act reasonably and prudently. So a lot of the allegations that we're going to talk about here under malpractice is that failure to act reasonably and prudently, and failing to adhere to those recognized standards of care. That third element that they must prove are damages. So in other words, if the person's not damaged, it's not really much of a case. In the attorney's world, no damage, no case. So as a consultant, you'll be helping that attorney with what are the injuries, what are the damages from COVID-19 or from the acts of the defendant in this case. And then finally, the plaintiff must prove causation. In other words, that the acts of the defendant did cause the alleged damages. And the way you'll think about it is the actual injuries that this plaintiff is alleging. Now, I will be addressing possible allegations and possible defenses, and our big focus here is going to be on the allegations and defenses that you can help the attorney develop in your role as a CLMC consultant. So I won't be addressing some of those legal allegations like breach of fiduciary duty and legal defenses like consent, because that's more of the role of the attorney. And basically what we're going to do is we're going to focus, as I said, on your role. Let's talk now about possible allegations. Now, when I talk about possible allegations for a medical malpractice case, I think it's important to understand, even though today we're talking about COVID-19, some of these allegations that you're going to see are very classic to any medical malpractice case. So, failure to timely diagnose COVID-19, failure to institute appropriate interventions. Well, failing to timely diagnose something or failing to institute appropriate nursing and medical interventions, you can see that kind of allegation in an MI case, okay? So some of these allegations are not new. They are specific, however, to COVID. So backing up, one is failing to timely diagnose COVID-19. Another is failing to institute appropriate nursing and/or medical interventions. So for example, there might be an allegation very specifically saying that an MD was negligent for prescribing hydroxychloroquine for off-label use. Okay, so giving some background, MDs are free to prescribe FDA-approved drugs for any scientifically supported use, whether on or off-label. However, they're going to be potentially liable for adverse events from the prescribed drug, especially if there is no scientific support for that off-label use. Significantly, in June of 2020, the FDA revoked the Emergency Use Authorization, the EUA, for use of hydroxychloroquine to treat COVID patients outside of a clinical trial. The FDA determined that the drug is not effective, that it has the potential to cause cardiac adverse events and other serious side effects. If a case were to go to court and there's an allegation about this drug, the plaintiff attorney would use the FDA revocation of the EUA as proof of negligence with any MD who used this drug after that date. Okay, now I'll make a comment under defense about this, so we're going to look at this again. Let me give you another example of an allegation of negligent intervention. The plaintiff might allege that remdesivir and dexamethasone are the standard of care for COVID patients, and that the MD failed to order those drugs that could have prevented mortality or could have reduced injuries in this person. Another allegation you might see in malpractice cases is that failure to assess and perform appropriate tests and diagnostic studies. Okay, so was there a proper assessment? Did they do appropriate tests and implement appropriate diagnostic studies? There also might be a failure to respond to the patient's deteriorating condition. So let's say, for example, somebody is hospitalized, initially they're hypoxic, and then they start to deteriorate and they develop severe respiratory distress. Did the providers respond appropriately and timely to this patient's deteriorating condition? So again, as you can see, many of these allegations that I'm pointing out here are allegations that we would see in a variety of medical malpractice cases. All right, now here's one of your favorites, negligent staffing and supervision. I was recently communicating with a CLNC who is involved already in some nursing home litigation related to COVID, and one of the issues was short staffing, because basically the nurses walked out, like they lost about 50% of their staff because the staff basically quit because they felt like they were not being properly protected and did not have proper PPE. So that could be an example of negligent staffing. Another issue around negligent staffing is the qualifications and the experience of the RNs. So for example, if we're talking about an ICU, okay, now, right now, at the moment of this presentation, we have hospitals that are already in surge capacity with their ICU beds, right? Okay, so it's not just, as you know, a matter of beds, right? We can get beds pretty much anywhere. It's a matter of what? It's a matter of the qualified staff. And so one of the things that you're going to want to be looking at is, was the staff experienced and qualified to treat these severe COVID patients? That's going to be very, very critical. Now, another example of an allegation is negligent administration of infection control by management, right? So that's more of that management supervision kind of issue. So let's face it, infection control is going to be a big issue with COVID. We all know that. What's interesting to me about this issue is it's somewhat unique to COVID-19, but it's not, right? So it's unique from the perspective that COVID-19 is new to us, but infection control principles are not new to us, right? They're basic nursing. So one of the things that might arise as an allegation is that management did not implement proper infection control. Another example of an allegation may be negligent lack of preparedness. So for example, the failure to provide adequate PPE and adequate supplies of ventilators. This was especially a big issue at the beginning of the pandemic, and also later in some of the areas that have spiked. Again, there's been a big strain on the healthcare system, and so this may come up in these lawsuits. There may also be an allegation of failure to provide policies and procedures regarding things like screening, infection control, containment, the use of PPE, such as N95 respirators versus typical surgical masks, that type of thing, and then P&Ps related to treatment of patients with COVID. So all of these things are things that you, as a CLNC consultant, are going to be able to educate that attorney about. Another allegation is the failure to provide adequate training to personnel treating possible COVID-19 infections. And it can be training with respect to PPE, with respect to the preparedness plan, to infection control, and to management of COVID. There also may be allegations of the fact that the facility violated state and/or federal regulations. Now, I will tell you that some of these allegations that I've mentioned against a facility, whether it's short staffing or violating state or federal regulations, some of those may be more difficult to prove, but they're going to be very important in these lawsuits because I believe that the individual providers are going to be more difficult to sue. And we'll talk about this more when we actually get into the defenses. Under allegations, you also can see abuse and neglect claims. And then non-COVID related, think about these doctors now that are practicing telemedicine. So could there be a failure to diagnose a non-COVID-19 medical issue due to practicing telemedicine? Now, I've had a virtual appointment and I'm going to tell you I'm a fan. I love it. There's no parking, no wait, no hassles. But we all know as RNs, not all patients can be assessed virtually. So is this going to be an issue? So we've talked about allegations for medical malpractice cases. Let's talk now about possible defenses. Now, as we talk about defenses, one of the things to recognize, especially the liability kinds of defenses that I'm going to address, these are usually in response to the allegations from the plaintiff. So this is how it usually works. The plaintiff files the lawsuit, and in that complaint or petition, the plaintiff states the allegations against the defendant. In the answer, which is a legal document, the defense is going to respond and react to the allegations, right? So their defenses are going to probably relate, at least from a liability perspective, to the allegations. Now, they may have some other defenses, like damage defenses and causation defenses, that they will also assert. So one example of a defense is if the plaintiff says you did not adhere to recognized standards of care, they're going to say, yes, we did. We did have appropriate adherence to recognized standards regarding diagnosis, testing, interventions, or response to a patient's deteriorating condition. So I mentioned as an example of a negligence allegation the use of hydroxychloroquine, right? Well, the defense might come back and say, well, wait a minute, that was appropriate because in July of 2020, a study suggested that the use of this drug in patients with minimal cardiac risk factors reduced mortality. And the plaintiff in this case had minimal cardiac risk factors. That might be an example of a defense. Now, I will tell you that right now the validity of this study is being challenged, but this is the kind of stuff that you're going to see going back and forth, okay? Now, this is a really big one, and this is actually one of my favorite defenses. One, that there's no actual standards of care at the time of the incident, and or that standards were evolving for this new disease and actually being developed in real time. And part of what, for me, legally makes COVID-19 so interesting is I would say that in my lifetime that never have I seen the ability to track how standards are evolving in the manner that we're seeing right now. This is just such a fascinating thing if you can just for a moment separate yourself from this horrific pandemic to watch how these standards are evolving. So this is going to be a big defense. So let me give an example. If you have a patient that's admitted into the hospital, well, that patient was put on a ventilator. Well, in April of 2020, ventilator use for patients who are not, or rather who are hypoxic and not in true respiratory distress was recognized as harmful to COVID patients. In fact, some medical professionals have acknowledged that in the beginning of this pandemic, they were treating the wrong disease initially, and they were jumping to ventilators too quickly. And in fact, this may have contributed to the high death rate at the very early days of the pandemic, okay? But if somebody was put into the hospital, let's say in mid-March, and put on a ventilator, it might be difficult for the plaintiff to prove that putting that patient on a ventilator was inappropriate, because the defense is going to come back and say, wait a minute, we had no standards, we're treating a brand new disease, we were treating this person's lung problems, because especially in the beginning, the emphasis was on how the virus attacked the lungs, okay? All right, another example. In April 2020, remdesivir was beginning to be considered the standard of care, right? In June of 2020, we had a trial that reported that dexamethasone steroids reduced the death rates by approximately 1/3 among severe patients. Now, what's kind of interesting is that probably most of us who are RNs, we go, yeah, that's right, because not surprising, COVID-19 causes inflammation and catastrophic issues. So why are we surprised that this would reduce death, right? But think about this. If you're an MD in July of 2020, you've got a more accurate understanding of COVID than that MD who was faced with these same types of patients in March of 2020. And so the standards in March are simply not going to be the same standards as they would be in July, or even more into the future. So if you have an MD in March of 2020 and somebody says you should have been giving remdesivir and dexamethasone, they're going to say, well, that wasn't the standard of care at the time of the incident. And then also, even later with remdesivir, there were unavailability issues due to supply shortages. So again, how can you say something's the standard of care if you can't even get access to it? So I think this whole concept of what is the standard of care, how it's evolved and will continue to evolve during this pandemic is going to be very interesting. Another example of a defense is that we adhere to crisis standards of care implemented by the state government. Okay, so crisis standards, these are based on the substantial change in the usual healthcare operations and the level of care that it's possible to deliver in the absence of necessary equipment, ICU beds, medications, personnel, or experience. So basically, crisis standards might apply, for example, to the peak of the pandemic in New York City versus to a city with controlled number of cases and available resources. So if you're working on a case, this might be an example of a defense. Now, another defense is that the plaintiff is relying upon junk science and/or there's no scientific support for the allegations. Now, I personally have been astounded by the amount of false information that has circulated about this virus. Friends, family, colleagues that I know and love buy into some of this stuff that we're hearing. But let me give an example of how the defense might say, well, wait a minute, this is not scientifically proven. The use of convalescent plasma in July 2020 was still investigational, and there is no proven safety and effectiveness at this time. So if the plaintiff asserts that an MD was negligent for failing to administer convalescent plasma, the defense would argue that there was no scientific support for this allegation because at that time, that was still investigational. Now here's one of my favorite defenses, and that is a theme related to the individual healthcare providers on the front lines. The RNs and the MDs on the front lines, these are the heroes of the pandemic. They have risked their own lives and potentially the lives of their families. Jurors may simply be unwilling to hold healthcare providers accountable for negligent actions. It's also going to be quite interesting to follow how the public sentiment towards healthcare providers impacts other types of medical cases, right? So this could be proving beneficial to nurses and MDs in other types of medical malpractice cases and how they're being defended by the defense attorneys in these cases. But I think this single defense is going to make it very difficult to go after individual RNs and MDs in medical malpractice cases. So the smart plaintiff attorneys are not going to want these cases to be about these heroes who are at the bedside. They're going to want the case to be about that profit-oriented institution that made those economic decisions that ultimately impact some of the big systemic issues that we had during this pandemic. Now, another example of a defense is possible state immunity granted to some, such as out-of-state volunteers or retired professionals, or to all healthcare providers treating COVID. And already there have been some states that have granted immunity to long-term care facilities for COVID outbreaks. So where there is immunity, a plaintiff cannot sue under negligence. They would have to prove gross negligence or an intentional misconduct, both of which are really difficult to prove. Now, even if the government doesn't offer immunity, again, will the jury grant their own immunity to healthcare providers? Staffing and supervision were consistent with recognized standard of care. This could be another defense. Another defense is we were adequately prepared, or if the jury believes we were not, or if they admit, hey, we weren't, then they might say the lack of preparedness and the shortage of PPE is not our fault given the magnitude of the pandemic and the global emergency. And in the hands of a smart defense attorney, this could be an effective defense. They're going to say, nobody could have been prepared. In fact, not many people were. And if anyone is at fault, they're probably going to try and blame it on the state and federal governments and the CDC, saying that they failed the healthcare system and the American public. From a defense perspective, they also will say we did have adequate policies and procedures given the magnitude of the pandemic and the global emergency, and we continue to update these P&Ps in real time. As to training, we did provide adequate training given the magnitude of the pandemic and the global emergency, and we continue to update training in real time. You also might see defenses related to we did adhere to state and federal regulations. If there's allegations of abuse and neglect, they'll try and prove that there was no abuse or neglect. All right, so for defenses, so far, we've been talking about liability kinds of defenses. Now remember earlier I said there's 4 legal elements: duty, breach of duty, damages, and causation. So the defenses that I've talked about so far, these are really saying, no, we did not breach our duty. We did act reasonably and prudently. We did adhere to recognized standards. But there can also be damage and causation defenses, okay? And so now I want to talk about some of those. One defense is that the person has had full recovery, and so there's really no damages. Now in the attorney's world, no damage is really no case. So it's not just enough to say that somebody did something wrong. We need to actually prove how the plaintiff was injured or damaged, or the damages are limited. Now, from a causation perspective, the defense is going to say we did not cause the patient's death or injuries. For example, they may say that the death or the injuries are due to acceptable side effects of COVID, and they were not preventable in view of the severity of the patient's condition at the time of presentation. So from a nursing perspective, you want to look at, what was this person's condition when they first arrived? And indeed, could they have made a difference? Additional causation defenses is the plaintiff's pre-existing conditions, which would make them high risk, right? So we know that people with comorbidities are at higher risk for death. Also, did they themselves contribute to their own injuries? Their comparative negligence. Perhaps, for example, a plaintiff delayed in seeking treatment. And finally, from a causation standpoint, the defense might argue the damages are acceptable complications of treatment necessary to save the patient's life. So for example, if a ventilator was indicated and a person has long-term lung damage as a result of being on a ventilator for 2 weeks, well, that's an acceptable complication of treatment that was actually indicated. Now, when you're working with an attorney, you're going to want to address both allegations and defenses, whether you're consulting for plaintiff or defense. Very tempting. People have very strong opinions about this virus, and it's very tempting to want to cling to your own opinions. But if you do, you're going to be of no value to the attorney. You have got to think like the opposing side. If you're consulting with a plaintiff attorney, you don't just give the attorney allegations, you also need to address defenses. If you're consulting with the defense attorney, you don't just give the attorney defenses, you've got to address allegations. So again, we talked about the plaintiff has to prove 4 legal elements: duty, breach of duty, damages, and causation. You'll be able to educate the attorney about all of these legal elements in your role as a certified legal nurse consultant. Now, other types of cases that we're about to talk about, things like general negligence and products liability, your role is probably going to be less about duty and breach of duty and more about damages and causation. And with any type of case, you're going to educate that attorney about COVID. There's a lot for this attorney to understand about COVID-19. But I want to stress this because there's so many different types of lawsuits that are going to be out there related to COVID-19, and you can get involved in a variety of lawsuits simply educating the attorney about COVID, about what were the injuries involved, are they really related, is it really caused by the actions of the defendant, or is it due to something else? So you don't just limit yourself to medical malpractice cases. The other thing I really want to stress is everything you do always comes back to what? To what you know as a registered nurse, right? So you might not be the expert on the rules and regulations of a bar, but can you explain how a bar with loud music, crowds, no social distancing, lack of mask is the perfect storm for transmitting COVID? Of course you can. Okay, so let's get into some of these other interesting categories. General negligence cases. Now, these cases can involve a wide range of negligence claims against a variety of businesses, corporations, and individuals. Examples of corporations include long-term care facilities, so again, nursing homes, assisted living facilities. Other corporations, airlines, cruise lines, rideshare companies, hotels, casinos, daycare centers, gyms, nail and hair salons, bars, restaurants. You can keep adding to that list. Examples of individuals include employees of long-term care facilities, massage therapists, chiropractors, hairstylists, other personal service providers. An individual could also be liable potentially for transmitting the virus after they have a notice, right, that they have it. Once a person's been diagnosed as infected, I think it's arguable that they have a duty to self-quarantine to protect not only their family, friends, and coworkers and their clients, but the public at large. All right, so let's talk about some possible allegations under a general negligence theory. One allegation is the failure to properly screen employees for COVID-19. Also, failing to inform customers of possible exposure to COVID-19. I know there was one hair salon that I read about where they failed to inform customers of a hairdresser, and there were hundreds of people that potentially were exposed. Failing to provide PPE, failing to provide safe air quality. Another allegation is the failure to implement safety policies such as social distancing, mask requirements, workplace sanitation. Failing to cleanse and sanitize the workplace. Although the more we're learning about this virus, there does seem to be lower risk of transmission with surface transmission versus airborne transmission. So depending on the case, you might want to steer the attorney toward stronger allegations. Also, the failure to implement state or federal regulations. So, for example, a long-term care facility may be sued for failing to implement infection control regulations. They also might be sued for elder abuse regarding rules and regulations about hiring, retention, and supervision. When you think about elder abuse, the plaintiff attorney doesn't want elder abuse just to be about an individual employee. They want it to be a management issue, right? That management contributed to that elder abuse. If you are involved in long-term care litigation, definitely refer also to some of the medical malpractice allegations. Now, possible defenses for general negligence cases. One defense is that we did provide adequate and appropriate protection for clients through screening, through informing customers of possible exposure, having adequate PPE, safe air quality, safety policies, and procedures. Another defense is we did adhere to state and federal regulations. Now, another defense is the plaintiff is just relying on junk science. There's no scientific support for their allegations. We can move now to damage defenses. The person wasn't really damaged. Causation defenses. We did not cause the plaintiff to contract COVID-19. In fact, the plaintiff contracted it somewhere else. Okay, so when we think about this, given that the incubation period is up to 14 days, it could be difficult to prove when and where the plaintiff contracted COVID-19. Think about this. If somebody gets symptoms 13 days after alleged exposure, a lot could have happened in those 13 days. So this would probably be easier to prove when we have a large number of individuals infected versus a single case. So for example, a group of nursing home residents, a group of cruise ship passengers, a group of hotel guests. From a causation perspective, one of the other defenses is that, well, even if the jury thinks that they got it from exposure because of our negligence, our actions didn't cause the person's death. It was really due to the severity of COVID at the time the person presented for medical help. And their pre-existing conditions, which made them high risk, is really what caused their death. Although, without getting into too much legalese, legally, the defendant takes the plaintiff as they find him. So if you happen to find a plaintiff that has lung problems, well, tough luck, you're going to be responsible for causing their COVID death, right? But again, just because that's the law doesn't mean that the jury might not be thinking about these issues, right? And they might be thinking, well, wait a minute, this person was already pretty sick and high risk, so we're going to give the defendant a pass. They might also defend based on the plaintiff's own comparative negligence. For example, the plaintiff's delay in seeking treatment. Now, another example of a defense is the plaintiff signed a waiver agreeing not to sue. Okay. Whether waivers are going to hold up in court is unknown at the time of this presentation. Government waivers, for example, attending a legislative session, are likely to be upheld. Private event waivers, campaign rallies, concerts, sporting events, residents in a long-term care facility signing a waiver, those may face stricter scrutiny. If you're involved in long-term care litigation, be sure to refer to medical malpractice defenses as well. Your role in general negligence cases is going to be heavy with damages and causation issues and a lot of education about COVID. How is it transmitted? Or you might be educating about PPE. And again, we'll get into a lot more specifically your role in part 2 of this presentation. Now, we've talked about medical malpractice, we've talked about general negligence. Another category of lawsuit that you might see is products liability. Now, these cases involve injury as a result of a defective product. And a large number of products related to COVID-19 are already known to be defective, unfortunately. So we are already aware of defective COVID virus tests with high false negatives, defective antibody tests with high false positives, defective hand sanitizers, defective and counterfeit PPE. Also, ultimately, we're going to have vaccines, and those vaccines may not be effective. And there will be potentially death or serious side effects from these vaccines. Okay, so when we talk about products liability cases, the plaintiff also, again, has to prove the same four legal elements: duty, breach of duty, damages, and causation. But the duty is a little different. The duty is to not produce defective products, right? And then the breach of duty is that they did produce a defective product. So there's three types of defects in products liability cases. There's design, manufacturing, and failure to warn defects. Okay, so let's get into each of these. Design defect. Here, what we're talking about is the entire line of product is defective. So for example, the entire line of a specific antibody test is only 50% accurate. A manufacturing defect, the way you want to think about this is there's one bad apple in the barrel, okay? It's a single product in the line that's defective. So generally the antibody test is 95% accurate, but this one bad batch of antibody test is only 50% accurate. One bad apple in the barrel. So you can have a design defect, the entire line is defective, a manufacturing defect, one bad apple in the group, right? Okay, another type of defect is the failure to warn. The failure to warn of defects, of foreseeable risk, or of known defects. For example, the failure to warn that an antibody test is 20% inaccurate. That inaccuracy rate may be acceptable given the pandemic as long as a warning is provided. Now, another issue with products liability can be fraudulent misrepresentation for holding out that a product meets standards which it does not. So, for example, an N95 respirator does not meet the filtration standards of filtering at least 95% of airborne particles. One thing that, I don't know if you've checked into antibody testing or the COVID testing, but I know when I was personally looking to get checked for the antibody test and I read all the disclaimers, it's like, oh my gosh, well, why do you see these disclaimers? Because of potential products liability, right? So that's why if you were to go get an antibody test, you're going to see a host of disclaimers. Possible defenses for products liability. One defense, the product is not defective. That's going to be the defense. And that can be from a design perspective or a manufacturing perspective, right? And when you think about it again, we're in a pandemic. A higher inaccuracy percentage of COVID-19 and antibody tests will be accepted than would be outside of a pandemic. In fact, all of our standards of what's acceptable are being challenged right now. I read that the first vaccines may only be 50 to 70% effective. That's a little bit frightening. These, however, are not normal times. Are we going to accept new normals? Because we are in the midst of a pandemic. Another example of a defense is that appropriate warnings were given or they were not indicated. Another example of a defense is representations were accurate based on what was known at the time. Another example of defense is that the plaintiff is relying upon junk science or there's no scientific support for their allegations that this product is defective. Another defense, a very interesting one, can center around immune defenses for manufacturers of vaccines, testing, and treatment products. Now, if we see immunity defenses, they probably will only apply to FDA-approved products and drugs. Okay, so what do immunity defenses do? They are designed to help protect corporations that basically are trying to produce these products at warp speed. Again, we are in the middle of a pandemic. And so the corporations, the view is that, wait a minute, what they're doing is for the better good of society. So is this test perfect? No. Is this vaccine perfect? No. But it's better than nothing. I'll give you an example of an immunity defense that already applies to vaccines here in the U.S. Title 42 of the U.S. Code protects vaccine manufacturers from being sued in state courts, okay? Basically, the U.S. Supreme Court has upheld the National Childhood Vaccine Injury Act, which preempts all design defect claims against vaccine manufacturers. So vaccine manufacturers, they are immune from being sued in state court. If someone is injured, they must go through the National Vaccine Injury Compensation Program, and they can be reimbursed for their injuries. But this is a no-fault system, and so basically damages are more limited. If a manufacturer is sued in state court, depending on the type of allegations, the damages and ultimately the verdict could be massive. But here we're talking about this person is only going to be compensated for very precise injuries that can be proven. So with the immunity defenses, I think when you think about the hurdles, especially with vaccines, I am predicting that we are not going to see any kind of large-scale litigation over vaccine-related deaths or injuries. I just don't think it's going to happen. And we may even see some immunity related to some of the testing as well. Now, another defense is limited or no damages. And another defense from a causation perspective is that the product did not cause the plaintiff to contract COVID-19. The plaintiff contracted it from another cause. Again, it may be difficult to prove when and where the plaintiff contracted COVID. Also, causation related, another defense is, okay, even if they believe that the product caused the person's getting COVID, the death and injuries are not due to that. It's due to the severity of COVID at the time they presented for healthcare, or they had pre-existing conditions which made them high risk, or their own comparative negligence, such as their delay in seeking treatment is what ultimately caused their death or injuries. With products liability cases, you may be able to educate an attorney specifically about those products because they are healthcare related, also damage and causation issues, and a lot of education about COVID. So we've talked about medical malpractice, general negligence, and products liability. The next category are workers' compensation cases. These cases involve job-related injuries. Workers' compensation laws do vary from state to state. So whether contracting COVID from work-related activities is compensable might vary from state to state. If it does apply, it can apply to any type of worker. So healthcare providers and ancillary workers within a healthcare facility. Think about the meat packing plant employees and the workers' comp associated with them. Flight attendants, office workers, any type of worker. Workers' compensation is usually the employee's sole remedy. In some states, employees can sue employers outside of workers' compensation for intentional acts or gross negligence. Both would be difficult to prove. However, when I think about, registered nurses and some of the conditions that they had to work under, especially in the beginning of this pandemic, I cannot help but think about, gross negligence. But again, in general, in a lot of states, workers' comp is that worker's only remedy. Now, possible allegations, well, that doesn't really apply in workers' comp because workers' comp is a no-fault system. Proof of fault is not required. The employer doesn't have to prove that the employer did anything wrong. All they have to do is prove that they contracted COVID-19 on the job. Some states have already enacted legislation providing a presumption of causation. So think about that. If you have an RN who contracts COVID and there's a presumption that it was acquired on the job, well, that just makes sense, right? I mean, yeah, could that nurse have gotten it somewhere else? But some states have already enacted that legislation, and they're saying, we're going to say that if somebody contracts COVID-19, they're one of our workers, that there's that presumption of causation. Other states might not have that kind of presumption, and they might just treat COVID like a common disease of life, like a cold or a flu, and it may not even be compensable at all. So again, workers' compensation will vary from state to state. Possible defenses in workers' comp, they still have to prove that they are damaged. They might not have to prove that the person did anything wrong or that the employer did anything wrong, but they still have to prove damages, and so the defense is going to be, well, you weren't really injured or damaged. In some states, they will have to prove causation. There won't be that presumption that they acquired it on the job. Basically, they're going to have to prove that the actual infection occurred at the workplace. And with America's return to work, when you think about things like commuting, traveling, restaurants, bars, beaches, gyms, worship services, casinos, and the general disregard for wearing masks and social distancing, I think proving it could be a difficult hurdle. In workers' compensation, heavy emphasis from your perspective as a CL&C consultant on what are the damages in the case and helping to prove or disprove causation, and a lot of education about COVID. You will also see workplace safety cases. Now these cases, these are also very interesting because these involve lawsuits where maybe somebody hasn't already been injured, but it's a lawsuit by an employee or the union representing the employees against an employer seeking injunctive relief from the employer to ensure a safe working environment. So plaintiffs, again, they can be any kind of worker. You can have healthcare providers, meatpacking plant employees, flight attendants, office workers, any type of worker. Possible allegations: failing to properly screen employees for COVID-19, failing to inform employees of possible exposure to COVID-19 in the workplace. We've already seen lawsuits already out there with some of these meatpacking plants like this, failing to provide PPE, failing to provide safe air quality. This is going to be a huge challenge, right, for places of employment. Failing to implement safety policies such as social distancing, mask requirements, workplace sanitation, failing to cleanse and sanitize the workplace, failing to implement state or federal regulations. From a defense standpoint, they're going to come back and say, we did adhere to standards and regulations. We did provide adequate and appropriate protection for our employees through screening. We did inform of possible exposure. We did have proper PPE, safe air quality, safety policies and procedures. Another defense is the lack of preparedness and the shortage of PPE is not the fault of the employer, given the magnitude of the pandemic and the global emergency. With workplace safety cases, your role is heavy education about COVID-19. If it's an air quality issue, maybe you're not qualified to speak to that. But if it's an issue about PPE and social distancing in the workplace, I think you're more than qualified. Employees can also sue employers for wrongful termination, discrimination, and constructive discharge. Okay, so healthcare providers, for example, they could sue an employer for wrongful termination if someone was terminated for insisting on adequate PPE, or they were terminated for reporting employer or employee misconduct, or they were terminated for reporting unsafe working conditions, or for wearing their own PPE. I remember this again was a big issue in the beginning of this pandemic with registered nurses. They were having to bring some of their own PPE to the workplace. And I've already heard of healthcare providers who have been terminated for either reporting unsafe conditions or coming into the workplace with their own PPE. You can also have a discrimination lawsuit, and this can happen if an employee is terminated, passed over for a promotion, or not hired based on age, sex, race, or disability. Okay, now we all know some people think this is a Chinese virus, right? So you have an employee, an Asian employee, applies for promotion, is passed over. The person who gets that job is less qualified. Could that be discrimination? Another way employees can sue is for a constructive discharge if they were forced to quit their job due to intolerable work conditions. Now think about this, when bars first opened, and at the time of this presentation, at least where I live, bars are closed again, but when they first opened, remember they were out of control regarding crowd size, lack of social distancing, failure to wear masks. All right, so you're a security guard in a bar, you're a bartender or service staff. Are you gonna have to quit your job because you're working under intolerable workplace conditions? If the answer is yes, then they may have a case for constructive discharge. With any of these kinds of employee cases, your role is to educate that attorney about COVID-19. Another type of lawsuit are intentional torts. These cases could include assault, battery, intentional infliction of emotional distress. So these are volitional acts. Intentional torts are volitional acts that intend to bring about actual or threatened transmission of COVID-19. Here's an example. A non-masker intentionally coughs in an employee's face for insisting the customer wear a mask. That could be considered an assault and a battery, and maybe even intentional infliction of emotional distress. Your role in intentional torts also is helping the attorney understand damages, causation, and a lot of education about COVID-19. All right, so far we've talked about a variety of categories of cases, all in civil lawsuits, right? Now you can also have criminal cases. So you've got civil court and criminal court. In a civil case, this is an individual's lawsuit against a defendant. Whereas in a criminal case, this is society's cause of action against a defendant. Criminal cases involve acts that society has deemed contrary to the public good. So let me give you an example. When I think about COVID, I cannot help but think back to HIV and back to the 80s, right? And if you recall, transmission of HIV and sexually transmitted diseases has been criminalized to varying degrees in many states, the majority of states in the US. It's possible that COVID may receive similar treatment if a person knows they're infected and they act without regard for the safety and well-being of others. To date, there are no states that criminalize transmission of COVID, but there are states that are already criminalizing threats of transmission of COVID. So be on the lookout because we may see this. There can also be criminal prosecution for fraudulently deceiving the public. So for example, you have an individual, you have an online reseller, you have a company or corporation that fraudulently deceives the public regarding representations of the quality and or the effectiveness of a product such as a mask or other PPE, supplements, alternative therapy remedies. So you take this supplement, you're never going to get COVID, that kind of representation. Already we have a Chinese company that faces federal charges for selling fake N95 respirators to American healthcare facilities. So it's very important to understand that fake products don't just happen to you and I when we order over the internet. They can happen to legitimate healthcare facilities trying to purchase products. This is criminal. There can be a criminal case against businesses refusing to close during the pandemic when mandated by law. And also there can be criminal elder abuse cases in long-term care facilities. And again, these are just some examples, okay? Elder abuse can also be filed in a civil lawsuit as well. But I'm just giving you examples of criminal cases. I'm not trying to give you an entire list. Again, we just don't have time for that here today. With a criminal case, your role is to help that attorney to understand COVID and to educate them about anything related to the case that would be relevant. Okay, so finally, there's that miscellaneous category. There are potential and already actual lawsuits that I don't want to spend time on in this presentation, but I just kind of want to alert you to them because again, as a certified legal nurse consultant, you can get involved in any type of lawsuit. It doesn't have to be just medical malpractice. In fact, we might not even see as many medical malpractice cases as we do all of these other types of cases related to COVID. So I want you to be aware that if there's something you can educate the attorney about related to COVID, well, it doesn't really matter what the case is. So you can have a lawsuit against the federal, state, and local government for negligently handling COVID. Arguably, this is unlikely to be successful. But as an example, there is a lawsuit against the state's Department of Health over nursing home inspection procedures, and that involved a nursing home that had a large number of residents infected with COVID. So that's a lawsuit that's already out there. There can be lawsuits against federal, state, and local governments for being forced to close down a business. I think we've already seen those out there. There can be actions by regulatory agencies against corporations for failing to adhere to regulations. Again, we're already seeing these actions. Lawsuits by businesses against insurance companies for economic losses due to COVID. Lawsuits against China for negligently failing to contain COVID. Those lawsuits are already out there. Lawsuits for failing to comply with state, local, or business mask policies. So for example, somebody is flying, refuses to wear their mask, placed on a do not fly list, they might file a lawsuit. Lawsuits brought under the Americans with Disability Act, the ADA. So you have somebody with asthma and they cannot wear a mask and they're refused reasonable accommodations due to their disability. Could be a lawsuit. Okay, you could have lawsuits from people who refuse to take a vaccine. There's a big anti-vaccine sentiment here in the US. So let's just say, for example, that a place of employment says, to come to work, you have to be vaccinated. Well, you might see lawsuits saying, I'm exempt from that mandatory vaccine requirement due to my medical exemptions or due to my religious, personal, moral, or other beliefs. Or the same could be related to a school requiring vaccines. Let's say a private school, for example. Also, lawsuits regarding failure to provide leave under either the Family and Medical Leave Act or the Families First Coronavirus Response Act, where applicable. Any type of lawsuit, again, your role, get in there, educate the attorney about COVID-19. Obviously, if medical records are involved, you're going to be helping sort them through that. Again, in part 2, we're going to get into all of the specific services that you're going to provide in a lot more detail. Okay, so what should you do if you're interested? Lawsuits related to COVID-19 are one of the newest and most emerging areas of litigation. This litigation is evolving as we speak. This is why I was sometimes feeling like Alice falling down the rabbit hole. These lawsuits have the potential to be one of the largest areas of litigation in your career as a CLNC consultant. You're going to want to decide now if and how you will participate. If you do want to participate, start researching now, start marketing now to law firms involved in COVID-19 litigation. You want to get in early, get involved now. A lot of people did not respect COVID-19, and we've all witnessed the tragic results of disrespecting this disease. It pays to respect the complexity of the upcoming COVID-19 litigation. If you don't, you're going to find yourself like Alice, falling down that rabbit hole. Remember to stick to your CLNC training and stick to what you know as a registered nurse, and you'll be fine. In part 2 of this presentation, I'll discuss more about the specific services certified legal nurse consultants provide and factors that will affect COVID-19 litigation. I look forward to seeing you there. Thank you.